Brought to you by GTA, your island, your network.
This is basic civics. This is fundamental civics, that everyone, regardless of race, has a right to vote.
Shortly before the new year, the Ninth Circuit Court of Appeals affirmed a decision on CNMI resident John Davis's case against the Commonwealth Election Commission. Davis filed a lawsuit alleging a CNMI law unconstitutionally limits voting on the basis of race. Political analyst and UOG professor Ron McNinch breaks it down.
The Davis CNMI case, the Davis versus the CEC case, is a case about voting over land issues in the CNMI. And the CNMI developed, kind of like Guam developed, its own kind of resident, traditional resident-only voting process, where if you didn't fit a certain category of voter, you couldn't vote. And the Judge Maclonia in the CNMI, when she had a hearing on it, she said, no, this is not appropriate. It's a 15th Amendment violation. There are other violations related to it. And so she found for Mr. Davis, she said, people have a right to vote. And then the Ninth Circuit Court of Appeals, upon review, said, yeah, absolutely. You cannot have, in the United States, on the 15th Amendment, you cannot have a race-based voting process or a process that excludes people on the basis of race.
According to the Ninth Circuit opinion, the CNMI restricts voting in certain elections to individuals of Northern Mariana's descent. The appeal relates to whether this restriction is race-based and violates the 15th Amendment. The Ninth Circuit concludes that it does and affirms the judgment of the district court. The 15th Amendment gives all men, regardless of race, the right to vote. Coincidentally, Guam has its own Davis case in the court, but for Arnold Dave Davis. Several years ago, he filed a lawsuit after he was prohibited from registering to vote on Guam's political status. Although the men are not related, McNinch says the cases are similar.
But the reality is the cases are almost absolutely political and judicial twins.
As it stands, Guam law only allows native inhabitants or a descendant of one who was naturalized under the Organic Act in 1950 to register and vote in a plebiscite. Dave Davis's attorney J. Christian Adams argued before the district court in September last year that ancestry is the same as race. McNinch says although not directly related, the CNMI ruling could have an impact on a decision for the Guam case.
I believe that Judge Gatewood follows decisions like this. We fall under the Ninth Circuit. It's a direct, it's a direct line. So of course it's going to be part of the consideration. I think that she's a sound jurist with good, very good legal reasoning skills, and I think that it's certainly a big part of it.
Reporting for Guam's News Network, I'm Ken Quintaniza.
Brought to you by GTA, your island, your network.